Okay, I guess we'll begin. Hello, my name is David Olshan. I'm with David Arbogast, who's a staff attorney here at Nevada Legal Services. Hello, David. You're muted, sorry. There you go. All right, so for our live stream today, we are going to talk about the Fair Housing Act and the Fair Housing Act amendments of 1988. Some of the big picture issues, and David, who has litigated these issues, will talk about the City of Oakland case, a case where banks have systematically discriminated against people of color, and talk about the ins and outs of that case standing, and how it could impact us here in Nevada, and basically just to go over some of the rights that you have under the Fair Housing Act. All right, so for the first thing I want to talk about is the Fair Housing Act is from 1968. It was a result of the protests and the racial strife in major cities in the United States. The Kerner Commission was created by the Johnson administration, and they wanted to do something. The Kerner Commission basically found that, wow, landlords were discriminating, and that different areas of major cities in the United States were segregated. And so they created the Fair Housing Act, which basically outlawed discrimination based on race, sex, national origin, ethnicity. And it was designed to basically attack some of the sort of systemic discrimination. And we will talk about some of the discrimination that Las Vegas practiced in the early years. The Fair Housing Act amendments of 1988, George H.W. Bush was behind that and signed the bill into law. 1988, it was meant to expand the reach of fair housing and include disability discrimination, which was sorely needed. It wasn't included in the Fair Housing Act originally, so they included it in 1988. They also included specifications for people who were building housing to accommodate people with disabilities, wider doorways, light switches, electrical outlets, things like that. So that's when we talk about the Fair Housing Act amendments, we're talking about the Fair Housing Amendments of 1988 that really opened it up for people with disabilities. All right, so let's talk about some examples. The City of Oakland case, for instance, we have banks such as Wells Fargo, Bank of America, discriminating against African American, Latinx people for giving them mortgage products that are more expensive and more likely that the homeowner will default, and partly creating the foreclosure crisis of 2008. So what we call this generally is reverse redlining, where people who are, in terms of the bank's value system, probably they're better able to take advantage of them. So they'll offer them subprime mortgages, and that's what the City of Miami case, the City of Los Angeles, City of Oakland, these cities later sued big banks because of their discrimination and because of the lost revenue as a result of the foreclosures and loss of tax revenue. So that's one example of discrimination and how the Fair Housing Act can help. Here in Nevada, the Clark County Commission put restrictions on, spacing restrictions on group homes. And we had one county commissioner, Lynette Boggs McDonald, who said, "Not in my neighborhood." These are called NIMBYs. And usually an elected official has enough intelligence not to say that in an open meeting, but she did. They were spacing restrictions that discriminated against group homes and people with disabilities. So Nevada Fair Housing sued under the Fair Housing Act amendments of 1988 that incorporated protections against discrimination against disabled people. And that case was successful, and it struck down the county's spacing restrictions regarding group homes. What we see also in Nevada, and you still see it to this day, is the City of Las Vegas basically carved out the west side for African Americans and basically practice redlining, putting a red line around a geographic area and forcing people of color to live in that area. That's redlining. It went on for a long time. And in fact, people of color couldn't stay on the Strip. They had to stay on the West Side. As far as I know, nothing was ever done about that, but that is an example of a city, the city of Las Vegas, discriminating against African Americans. So how does discrimination, how does it manifest itself in day-to-day activities? Well, if you go to an apartment and the landlord says no, and the reason the landlord is saying no is based on your race, your ethnicity, perhaps your religion, that would be a violation of the Fair Housing Act, and that would be unlawful discrimination. If you're being evicted, if the landlord doesn't want you because of any of the prohibited classifications, race and ethnicity, religion. In Nevada, we have a couple of other protections based on gender identity and gender expression. If you're transgender, for instance, and the landlord doesn't want you and the landlord evicts you based on that reason, it would violate Nevada's fair housing statute, NRS. It's contained in NRS Chapter 118. Also, there's ways to discriminate if you if you have different terms and conditions for the sale or rental of housing, that's based on one of the prohibited bases, like race or ethnicity, that would be a violation of the Fair Housing Act. For instance, children, not allowing children to use a pool without parent or a guardian supervising them. That's discrimination against families with children, and that might violate the Fair Housing Act. What I talked about earlier, redlining and reverse redlining, when you sort of carve out a neighborhood for a particular race, that's violating the Fair Housing Act. If you steer particular tenants in an apartment complex to a portion of the complex that's sort of earmarked for people of color, that's called steering, racial steering, and that violates the Fair Housing Act. Also, your advertising can't discriminate. Sometimes you'll see advertising that says no kids, for instance. You do see that a lot, and we will talk about situations where it is okay to discriminate against kids or people under 55. But if your advertising discriminates, that's also a violation of the Fair Housing Act. All right, so HUD enforces the Fair Housing Act. If you have a complaint under the Fair Housing Act, you can file it with the Department of Housing and Urban Development. They've also promulgated regulations, and those are in 24 CFR 100.1 to 100.600. And they basically talk about different ways that discrimination occurs. They talk about discriminatory practices and provide, concrete examples of when this occurs and different sort of standards of evidence that you need to prove up your claim. So if you do have an issue, you want to know if it's prohibited, you can go to the statute 42 USC 3600, or just go to the regulations, because the regulations really have the particular circumstances that constitute discrimination under the Fair Housing Act. All right, so how do you prove your claim under the Fair Housing Act? You can do it through direct evidence, disparate treatment. For instance, if you have zoning that excludes African Americans, that's redlining, that's actual facially discriminatory treatment, and that violates the Fair Housing Act. You can also do it, and the Supreme Court has recently upheld this basis. You can prove discrimination by statistics. So landlords, banks, people who want to get away with discrimination but don't want to overtly say it, they will create policies that discriminate. So if you exclude low-income households, that is discrimination under the Fair Housing Act, and you can probably establish it by statistics that show these exclusionary areas, these income exclusionary areas are largely composed of people like whites, as opposed to lower income areas that might be people of color. If that's what's going on and you can prove it by statistics, you don't really need actual disparate treatment. You don't need a landlord to say or a municipality saying we're discriminating against African Americans. It's based on this benign sort of neutral language that has the effect of discrimination. And so this effect was supported by the Supreme Court, and it was challenged, but it is allowed under the Fair Housing Act. You can establish a fair housing plan by statistics. All right, I touched on this a little bit. Congress has carved out some exceptions to the Fair Housing Act. Housing for older persons is probably the biggest exception. You can discriminate against younger individuals if you are a housing development or an apartment complex that's an older person complex. Sun City, for instance, they have a 55 or older rule, so anyone 55 or under usually cannot live there. To comply with the Fair Housing Act, to allow this discrimination, there's specific rules that apply, and 80% of the residents in Sun City, for instance, have to be 55 years or older. Now, these verifications, these strategies have to be supported by evidence and a survey of the residents. So if you believe that people under 55 are living in that particular area, and they're not complying with the Housing for Older Persons Act of 1995, you can challenge it. So you can challenge a senior complex or a senior development if you are pretty sure that there are younger people living there and the HOA or whoever's in charge is not complying with the 80% or at least 80% of the residents have to be 55 or older. Also, smaller landlords, if you own less than three dwellings or less, or you don't involve a real estate agent in the sale of or rental of your property, you're immune, you're exempt from the Fair Housing Act. And also religious groups can discriminate. They don't fall under the restrictions of the Fair Housing Act. All right, so David, we're going to start talking about some of the issues. Standing to sue under the Fair Housing Act is rather broad, and the Supreme Court has dialed it back a little bit. But basically, if you're a person who's been discriminated against, or you're an organization that's in the business of enforcing the Fair Housing Act, you usually have standing to sue, and that allows you to go into federal court and seek relief if you have been damaged by discrimination under the Fair Housing Act, or if your organization has used resources to investigate discrimination. Now, what David has done and what other sort of advocates have done is they've tried to broaden that standing to include cities and governments and allow cities, for instance, the City of Oakland, to sue Wells Fargo because of reverse redlining, the foreclosure crisis, and the discrimination that violates the Fair Housing Act and the damage that the city suffered as a result of lost tax revenue. So, David, do you want to like go into how this case developed and the history sort of behind sort of these cases?
Yeah, well, the city cases, they started out and they didn't really go very far. They started in 2013, and the first attempts were losses. And basically what the cities were realizing is that because of the discrimination, the marketing of these poor loans, bad loans, higher, costlier loans, the cities were actually losing money in terms of tax revenue. They're also, because of the blight of foreclosures and the lower tax revenue, they were having to pay more money, more expenses. And the seminal case that really opened the dam to wins was the City of Miami, which went all the way up to the Supreme Court and opened it up for cities to get compensated for the losses that they suffered as a result of the discrimination. So in, for instance, in the City of Miami, that was a clear win. And what they've noticed in the litigation is that the success of the cases largely depended early on the discovery they obtained. If they got the data set of what the banks were really doing and took the depositions of the corporate executives as to their policies, the banks settle. They don't get that, like in the city of Los Angeles. That ends up in, the banks fight it, and it ended up in a summary judgment against the city.
Well, so let's just say you don't have that discovery. Are these cities basically trying to prove up a case simply because there were greater foreclosures in these neighborhoods of color? I mean, if you didn't have that evidence, which of course is great evidence because you can see how they manipulate home buyers into buying more, these subprime loans. Well, let's say you didn't have that evidence. What is the problem if you don't have the evidence?
The problem is that you can't prove proximate cause. So, you could obviously prove the but-for causation that as a result of the discrimination, they've lost revenues. However, you have to back that up with some sort of evidence. And what the City of Miami and the cases have shown, that through a regression analysis, a standard statistical analysis that businesses use to determine profitability, that they can go and look and see what the city has lost as a result of the discrimination. And so they're very important to get the data set so that you can show proximate cause, because if you don't have the data set, you can't prove causation.
But David, let's take a step back. When you're talking about proximate cause, you're talking about the discrimination is the proximate cause of the injury.
Yes.
Okay, good. Because that was what the Supreme Court basically said in the City of Bank of America versus City of Miami.
Correct.
Okay, so then when you talk about regression analysis, you're basically, this is the analysis whereby the discrimination, the reverse redlining, causes the damage to the city, loss of tax revenue.
Yes.
All right.
The City of Oakland also alleged, and they lost on the panel decision, as to the increased costs, that the city had to spend more money. Not only did they lose revenue, they had to spend more money because of the blight of foreclosures in the neighborhood.
Right, right. Yeah, the Ninth Circuit pretty much rejected that argument.
Yes.
Which, that distinction doesn't really make sense to me, but I don't.
Well, it's all going to be relitigated and re-argued in the en banc hearing. So the entire panel decision below is now no longer citable. It's no longer controlling authority, and it's all being re-argued.
Why do you think that it's the bank that's doing this, right? The bank asked for en banc review.
Yes, the bank petition for rehearing, and why? Well, the makeup of the panel has changed. And that's the scary part of this, is that there are quite a few Trump appointees on the Ninth Circuit, and 2 of the 4 Obama appointees have recused themselves from the panel. So that's the scary underbelly of the en banc review. But it's clearly under Scalia's opinion and that generated in out of City of Miami and also Breyer's decision that that the claim should go forward. I mean, this is still at the pleading stage, so they're 8 years down the road and they're still stuck at the pleading stage.
Do you have any idea how much the city of Miami, in that case, settled the City of Miami?
No, I do not.
Oh, okay. What's Wells Fargo looking at in terms of the City of Oakland case in terms of liability?
I do not know what the dollar amounts are. It's in the multiple hundreds of millions of dollars.
Okay. I would think so. Lost tax revenue in Northern California, it's probably pretty substantial.
And for a number of years, because it was a continuing violation. So it goes back to whenever they started the conduct. And the conduct started in the 2006, 2007 time period. And so when I was talking about the error in getting the discovery, you don't get the data set that goes back to that time period. You really do not see the start of the discriminatory practice, and you don't capture the full damages. And therefore, you have a problem with showing proximate cause as well as proving up your case.
Yeah, no. It's just, it's unfortunate, and probably the City of Miami case injected too much sort of technical mumbo jumbo into the case to allow courts to let banks off the hook for their clearly discriminatory practices. But that's the nature of the law, and that's why we get the big bucks, I guess. Let's go back to this regressive, what's it called? Regression analysis. Sorry. So what you found in City of Oakland, minority borrower was 2 to 4 times more likely to get costlier or riskier loan than a non-minority borrower. That's basically it.
Yes, I mean they were
well,
the horrible loans that they couldn't sell to non-minority people. And they marketed them because they're very profitable for the banks, and they could focus them and offer those products to non-minority borrowers, and excluding the better loans, the better products from those areas. So they purposely marketed those bad products to the exclusion of their good products to those areas.
But 2 to 4 times is 200% to 400% more likely. I mean, I think you diminish it when you call it 2 to 4. I mean, it's basically a lot.
Yes.
And
that's right out of the briefing, and that's how the plaintiffs have categorized it, but it's significant. I mean, it's a significant statistical proof that the discriminatory policies of the bank that on their face may be non-discriminatory, but in effect are highly discriminatory.
What we're talking about is a higher interest rate on your principal. What we're talking about are balloon payments that after 3 or 4 years, you have to pay hundreds of thousands of dollars to keep the loan current. Just many ways, forced placed insurance, forced retention of escrow that perhaps is higher than other lenders or other borrowers. These are ways, very easy ways that people can slip into foreclosure if your monthly payment is too high, if you incur all these fees and can't pay them back, if your escrow is short and you have to come up with a lump sum at whenever they sort of recalculate your escrow. These are all ways in which they can just force you into foreclosure.
And also the option arm loan, which provides an introductory interest rate at a low interest rate, showing that on the truth in lending disclosure statement that their payments are going to be low. And the entire 20-year mortgage is calculated on that interest rate that's only applicable for, let's say, 30 days. But then after 30 days, that interest rate changes under adjustable rate mortgage component of the mortgage. And so all of a sudden you have these balloon payments that are never disclosed, never explained, and people are stuck with these loans they cannot afford, because had they been truthfully disclosed to the borrower, their payments would have been 2 to 3 times higher than what the disclosures say. And so those loans, a smart investor may look on the internet and compare those, but in places where people do not have the capacity through poverty to do the comparison and do that, that's how they were able to commit the fraud.
Well, look, I think, nowadays people have phones, smartphones, and like there's mortgage companies, there's bankrate.com. There's ways that you can see what the sort of going rate is for a 30-year, a 40-year, 15-year mortgage, and then judge whether the terms are good for you. And I think that's what, home buyers should do, is do that research. And I think these banks made that assessment. Yeah, people of color may not be doing that. And that's why they took advantage.
Correct.
All right, so let's talk a little bit about what you've done. Oh shoot, June 21st. All right, so hold on. You filed an amicus brief on behalf of, what's CBCC?
The California Black Chamber of Commerce, probably the only chamber of commerce in the country, if not the history of the United States, to ever write on behalf of consumers. I've done quite a bit of amicus work, and the Chamber of Commerce always comes on the side of business, and that's what they do. However, discrimination of this sort hurts business. I mean, it's not in the business interest. If we're all colorblind and we're just out there being good capitalists and earning money, race is not an issue. I mean, it's the idea of having the best products sold to people with money and having more and better products is harmful to businesses. And so businesses are harmed, yet they don't have standing. And yet Wells Fargo has always come to these oral arguments and argued that the businesses are the ones that are being harmed the most, and the businesses are the ones that should be standing up and claiming that they've been hurt. However, a business's loss is very attenuated, and that's why Wells argues that. The city has a concrete, definite harm that's provable. They've lost tax revenues.
Right, but you make the good point that fair housing, that avoiding discrimination, promoting diversity is good for business. And economists always sort of support that view, that discrimination actually harms you in terms of your bottom line. And it's really counterproductive if you're in business to make money, but still you discriminate. Those are two sort of contrary sort of positions. And if you are in business, you should want more customers and want more diversity, not less.
Correct.
All right, so let's give a shout out to your co-counsel or people that you're working with.
Yes, Robert Peck with the Center for Constitutional Law will be arguing on behalf of the city. And then if you're a fan of MSNBC, you've seen Neil Katyal. He's always publicly viewed as a liberal, but in the real world, day to day, he argues on behalf of corporate interests. And he will be arguing on behalf of Wells Fargo Bank. It should be an excellent oral argument. Two excellent attorneys, appellate attorneys, both have extensive experience before the U.S. Supreme Court. Their briefing was just stellar, and it would certainly be, if you're a fan like me of legal arguments, it certainly should be a very good argument to watch.
Right, right. No, the Ninth Circuit is very good. The Nevada Supreme Court isn't, I should say, but the Ninth Circuit, it's on YouTube. You have the link right there. So I would encourage people who are interested in what we've been talking about to watch the oral argument, because you can really see the positions, and you'll see Wells Fargo Bank have a public sort of image that's completely undermined by their lawyers and their real position. I think that's the best thing of all. You kind of see how duplicitous they are, and they want to be, well, we favor inclusion and diversity. Well, they really don't. All right. There's your brief, the title page, the cover page, sorry. And yes, June 21st in front of the Ninth Circuit, we're going to see the reach of the Fair Housing Act and whether banks can be held responsible for the systemic racism. David, do you have any final thoughts?
Well, and the determination of the en banc panel may just be another bump in the road. This case may very well end up before the U.S. Supreme Court, regardless of however it turns out. There will be petitions to the Supreme Court, and we may see that sooner than later.
Yeah, no, that's what I was going to say earlier, is this is probably going to the Supreme Court. And that's the reason they moved for en banc consideration, and they want to develop that record. It's unfortunate, and I don't know. City of Miami was a decision by Scalia, right?
Yes.
Yeah, but I don't know. I think it's probably more conservative now. But we'll see, and we'll see how all these issues work out. Again, June 21st, the Ninth Circuit. You can hear this oral argument. You can see it on YouTube. You can see it on the Ninth Circuit's website. And we will be back in 2 weeks for another live stream. David, thank you. It's been most informative.
Thank you.
And we'll